Welcome, everybody. If I could have everybody start to take their seats, we'll start with a couple announcements that in addition to introducing the speakers, please make the following announcements. Remind those taking the course for MCLE credit, please sign in the back of the room. The sign-in sheets are goldenrod in color, not to be confused with yellow. The links to materials are available before today, and they were emailed to you on Wednesday. They are also available on the MCLE Spectacular page on the CCCBA website. Additional materials may be added after today's program. Your attendance certificate will be available and emailed by mid-December. If you are a CCCBA member, your attendance certificates will also be located in your My Events tab on our website. You may download your certificates by going to our website, www.ccccba.org, and logging in. Please fill out the evaluation form and drop it in the box at the registration desk, or scan and email it to Ann Wolf. We would appreciate constructive feedback. A Wolf, that's AWOLF, at ccccba.org. Thank everyone for coming to our 28th annual MCLE Spectacular. Thank you for coming to our 28th annual MCLE Spectacular. I will turn it over to Lara for introductions.
Good morning, everyone. It's so nice to see everybody in person. So now we can actually watch you look at your phones while we're talking instead of just seeing you on Zoom. So yay! I just want to do a quick introduction to you guys. A lot of you we all know, and we're so happy to have you here. My name's Lara Heisler. I am a estates, trust, litigation, conservatorship, and guardianship attorney. I mostly like guardianships and conservatorships, and my partner Rachel does the rest and everything, because she's smarter than me. And I started out in criminal defense, and I was looking for something as exciting and sexy to get into, and because criminal defense is a little rough, and I found probate law, which I'd always thought would be so boring, but it turns out that we get to see the best and the worst of people and their family dynamics, which is what I love. So that's me. And part of the reason that I got into probate law is because this gentleman sitting next to me, Oliver Greenwood, and I shared a friend who loved his job, Bob Kozloff, and he loved what he was doing, and he said, if you're not happy being a lawyer, you should get into probate law. And that's how Oliver and I got involved, and Oliver has his own firm now, and he does guardianships, conservatorships. He's been very involved in helping draft legislation, some of which we're going to be talking about today. And I also have Dr. Melinda Ginne, and she is a geropsychologist, and she has an incredibly impressive resume, and she'll go over a little bit of her background. She does capacity evaluations, she does neuropsych evaluations, and so much more, and works with families, and she's going to have a lot of great information for us as we go through. So we're talking about conservatorship law, and I know that some of you have been practicing for a long time like me, and it used to be that when you were appointed by the court to represent a conservatee, you would go and meet the conservatee, and you would make a report to the court about what the conservatee wanted, and you could also kind of talk about what you thought was best. You had a weird hybrid role of advocating for what the client said they wanted and for best interests. And then things started.
When you say hybrid, that's kind of almost attorney / guardian ad litem / best friend of the court.
Exactly.
I think would be really a good description of what the role was of the court-appointed counsel for the conservatee.
I remember meeting with one of my first clients, and her grandchildren were so worried about her, and she was living alone in an apartment, and she did not want to go to assisted living. She did not want to have any help. And when I met with her, I'd never seen her before in my life. I knocked on the door, she welcomed me in, her door was unlocked. She had, weird food out. She had glasses with no lenses in them. And she was very clear on one thing, which was that she didn't want to be conserved and she didn't want to move. And so I remember saying to the court, my client doesn't want to move, and she doesn't keep her door locked, and she doesn't have lenses in her glasses. So it was kind of like you could kind of wink and nod to the court, and they would know what you meant. But then things started to get weird. So what changed? Well, it's Brittany, and we all know that when there's a high-profile situation like Brittany's, it brings a lot of scrutiny to the way that things are done. And that is when AB 1194 kind of kicked in. Do you want to talk about that a little bit?
Sure, and it started before that, but it really brought it to the forefront of everybody's attention. It got a lot of publicity, and the changes that were coming, not too many people cared about in the public eye. Most people didn't care about court investigator reports. Most people didn't care about court-appointed counsel. They had no idea that an attorney was appointed to represent anybody in a conservatorship matter. They had no idea that a court investigator existed. In fact, I'd say most people in the legal world still don't know that. But this brought that out, so these questions started coming up. And these changes started slowly infiltrating in, and we saw movement within the legislative system. And at the time, I was sitting on the Judicial Council's Probate and Mental Health Advisory Committee, and I was the chair of the legislative subcommittee when AB 1194 was coming through. So it was really quite the adventure to see the process take hold and what was coming down the pike, because the way we saw it was not how really the general public was seeing it, of course. We were looking from a fiscal impact on the courts.
And this is how the public was seeing it.
Yes.
The public was seeing it as a bunch of lawyers are trying to take old people's money and kick them out of their houses, and that the younger generation was pretty merciless, and it was all about control. And there was a lot of bad press. There was a big article about conservatorships in Las Vegas. There was a big article in the LA Times about abuse of conservatorships. And so scrutiny started happening. So I think a lot of you know now our role as court-appointed counsel is very clear. We are zealous advocates for what our clients say they want. It is not our job as court-appointed counsel to try to figure out what's in their best interest. It's not our job to convince the court to have the person conserved.
So Lara, what does that mean for the person not wearing lenses in their glasses who does not want to leave their residence as you're representing them?
It means that I probably don't say any of that. And I just say my client feels very strongly that she does not want to leave, and my client wants to remain in her home. And my hope as court-appointed counsel will be that the court investigator made clear all the reasons that I used to feel as court-appointed counsel, that it was my job to reveal that. So this is all about empowering conservatees through court-appointed counsel. And let's see.
But you just mentioned that the court investigator also, and this is another modification that came through in Probate Code 1850, that now it's annual investigations, whereas this was really loosely held before, that there were supposed to be investigations, but now it's annual, and they have to be actual investigations. This was the fiscal impact that we were worried about at the Judicial Council that was going to greatly affect the courts. And it certainly has. It's an impact for really the manpower of going out to do investigations and the fiscal component tied to it. Now, there's an additional eyes on there. So what Lara was just saying, the zealous advocacy that is happening with the court-appointed counsel, yes, that has to occur, but hopefully there are eyes on the conservatee or proposed conservatee that are on a more frequent basis.
Yeah, and we'll talk about all the different checks and balances that exist to make sure that the conservatees' civil liberties are being protected, and also that there are safeguards for our aging population who may need the help and support. Let's see. So another change in the law was that it used to be that the court could appoint counsel. Now the court must appoint counsel for the conservatee, which is a good change. And they, again, are charged with representing what the client wants. Yes, Rachel?
So do we always, from a practical standpoint, would we always submit an order of appointed counsel request that will be appointed in our interpretation petition?
So the court is going to do it automatically, but I feel that at least in Contra Costa County, they're still, I feel, working out the kinks of how to get counsel appointed. It's not an easy, streamlined process. It goes, the judge says, I want a court-appointed counsel, and then it goes to the clerk, and the clerk goes back to the probate examiners and says, we need court-appointed counsel, and then the probate examiners call the conflict program, and then that goes through a rotational list, and it ends up sometimes taking up to a month or two from the time of granting of a temporary conservatorship for counsel to be appointed. So I think the better practice in Contra Costa is to always request appointment of counsel. Sometimes the conservatee has their own counsel, and that's when things can get a little sticky. Do you want to talk about?
Yes, because now there were educational requirements for court-appointed counsel. And those, now if somebody shows up and they say that they have retained their own attorney, then they get their own attorney. So the educational requirements for court-appointed counsel are kind of out the window from what they were before, which is a bit distressing. So you can have somebody who has no experience ever representing a proposed conservatee now representing a proposed conservatee. Yes, in the back.
So in light of the fact that the legislation requires that they can keep their own counsel, what are we supposed to do in a situation where the abuser is paying for the attorney and it's clear that mom or dad doesn't have capacity? Do we just kind of blind eye?
So the question is, if we know that the person that we've been appointed to represent has counsel and we question the legitimacy of the counsel, what do we do?
I would say bring it up, absolutely. And I would request that counsel be appointed in addition to who is the person that's been appointed. And that's my recommendation.
Or if you're appointed, I think another kind of workaround you could maybe do is suggest to the court that this case might be an appropriate case for guardian ad litem.
I think you have to have the determination of a incapacity.
We'll get to that.
Yeah, I know, okay.
Yeah.
I'm jumping ahead,
Yes,
so it's.
You do have to have a determination of incapacity, and if your client has said things to you that lead you to believe that they are incapacitated, then it's covered by attorney-client privilege. But let's say, the abuser indicated to you, oh, I've got my long-term attorney working on this, and don't worry, I'm paying for it, then that would fall outside of the attorney-client privilege communication, so it would be within your ethical parameters to speak up, indicating that there may be something that needs to be done. Or you can always call the court investigator and give them a heads up. There are a lot of workarounds. Let's see. I don't want to go crazy going through all the legislative changes. You have it in your materials. I'm putting it up here. But if you have any questions about the changes, please feel free to interrupt and we can go over it in more detail. Yes, Rachel.
So, I know that in some conservatorships, especially if there's already general conservatorship or temporary place, that there used to be petitions to retain private counsel. So does the new changes do away with that requirement? Or you don't have to do that?
Yes, yeah, there's no need to petition to retain private counsel. The proposed conservatee can just retain private counsel. Yes. Yes.
Is that, and that's true even if there is a conservatorship already in place with a capacity declaration that says incapacitated, or is that in a gray area?
If the capacity declaration is, I believe they're still entitled to retain their own counsel, yeah, even with the capacity declaration. The wording of the code section is the way it is. They're still entitled to it.
But I guess the question is,
Do they have?
Should you?
Do they have the capacity to contract?
is it a good idea for you as an attorney? Yeah, Amber.
Who pays for private counsel? So you've got it, you're retained before the temporary is in place, who pays the private counsel?
The fees would be subject to court approval, since it is a conservatorship. And it would have to probably come from the estate. Are you saying, would it come from the?
I someone comes into my office, she seems fine with me, I sign her up, she signs a contract. And maybe she brings in a note from a doctor saying she's competent, there's a conservatorship proceeding, the court puts a temporary on there. She can't comply with the terms of her contract, and then I'm stuck as private counsel, waiting for 2.5 years until I can get paid.
Correct.
Yes, well, and that's the nature of all conservatorships.
Sure, but I'm just saying, as private counsel, you've got to be really careful, because you think
Yes.
you've got something going on, that'd be your team, right?
Yes.
Well, exactly. Getting a big retainer is a big deal, but what sort of the reason that we're here talking about it is, do I say yes? When do you say yes? And when is it smart to say, this is not a good idea? Because you can get a big retainer, but if you think that your client is okay and the entire family does not, it's probably going to be a big fight and it's going to last a long time. So it's a really slippery area as an attorney to be retained. And the court is getting a lot more discerning about granting attorney's fees. Some of us remember with Judge Sugiyama, he was so grateful that anybody was doing conservatorship work that he was like, you want $200,000? Have at it, yes. And he also, and I think that this is something that probably happens to many of us practicing for a long time, is that you start to get pretty jaded and be like, all right, if the family can't figure it out, let's just, instead of the family getting a big inheritance, we'll just pay the lawyers. And I think that that sort of jaded edge does come into play from time to time. So Oliver talked about how if you want to represent conservatees through court appointment, there are requirements, and this slide shows you what some of the requirements are.
So yeah, if you want to represent through court appointment, there's requirements, but if you want to represent conservatees without being court appointed, there's no requirements.
You could have just passed the bar and be into criminal defense work or whatever, and you get a nice conservatee who presents well, and there you go. So let's see, I want to talk about some of these ethical issues that come up when we're dealing with conservatorship or elder clients. So we were talking about what if a conservatee brings in their own attorney, or what if someone comes to, let's say you're a new estate planner and you haven't done any elder abuse litigation, or you haven't done any conservatorship work, and a private senior wants to hire you. Be careful. Bring someone in. There are rules about having a reasonable knowledge, and this is a pretty specific area of the law. So looking around the room, I see a lot of experienced attorneys here, but you do want to be careful when you're saying yes to a client, to make sure that you have the skills reasonably necessary to be a zealous advocate. And let's see. It gets a little murky, again, when our job is to abide by a client's decisions when we know that our client is being subjected to undue influence or has major cognitive impairment. And the rules are very clear that you abide by a client's decision to the best of your ability. Now, the best way, I think, to look at your role as court-appointed counsel for a conservatee is it's very similar to like what I used to do in criminal defense. I'm not about questioning the morality of what I'm advocating for. I'm about advocating for what my client is telling me. And if your client is clearly asking for something that's objectively harmful and dangerous, the hope is that when you tell the court, my client would like to continue living in the basement of their house while their adult children run a meth lab upstairs, that the judge is gonna know that that's a bad idea, and you don't have to worry about it. And this goes to your attorney-client privilege is still a big deal. So it does become a little bit of a ethical morass if you have a situation like the one I just described. What is okay to reveal and what is not? Does anybody have any examples from their own practice of times where maybe a client said something that you felt made very clear that there was a cognitive issue and you struggled with whether to reveal that to the court or not? Has anyone had that experience? Well, be on the lookout.
Yeah, I have one. Not the best of examples, but an example all the same. I was at my client's kitchen table several years ago. She's long since passed. And we're having a discussion about a matter, and she says, well, you need to ask my husband. And I said, oh my gosh, your husband passed away a couple years ago. She breaks down into tears, starts just completely just overwhelmed, just crying. And as if this is the first time that she's heard anybody tell her that her husband has passed away. Just distraught. I'm like, oh, wow, this is incredible. And she finally calms down. I ask her the question again, and she starts to cry. Or no, she didn't cry then. She said, I have to ask her husband. And I say, your husband is in the other room, and I'm going to ask him in a couple minutes. And so that's something that I did not share with the court because it's very, very messy and very clear that she was not competent at that point to me, and it just wasn't necessary. Yes.
So I have a question, when you go in to meet with clients, particularly in this area, you're meeting at the home, what is your guidance on evaluating, telling the court about things that you objectively see versus kind of the subjective nature of your communication with the client? Where does the attorney-client privilege, how does it accommodate that objective, I'm seeing this, I'm smelling this, I'm hearing this, these are my observations, versus what because I always think attorney-client privilege is what they're telling me, what they give me. But I think arguably the access to all this additional information could be argued as attorney-client privilege.
I agree. It's really murky from where I'm sitting, and I tend to be of the more protective school of thought. I'm more worried about the person getting hurt than about their civil liberties being compromised. I just am. That's my personality. So I would probably tend to feel justified in disclosing things that I thought showed a clear danger by doing that as a workaround and saying, my client very clearly doesn't want to be here, but this is what I observed. Or, because I don't really think I'm supposed to do that, I would probably call the court investigator and say, I'm just wondering, when I was there, XYZ was an issue. Was it an issue for you? And we're going to talk about how helpful court investigators can be.
And I wouldn't say anything about my observations of those because those are probably observations other people had already. I wouldn't find them very useful or helpful, and they're just my own personal observations. And then I always struggle with my own morality that I'm putting on other people when I'm entering their homes, because I think other people are really messy. When I go into their homes, just know that when you invite me to your place, I think you're much messier than me. And if you saw my home, you'd say, that's really odd. But so I struggle with that. And so I'm always conscious about maybe putting that on anybody when I'm going to their place and reporting back on anything like that.
Are we just talking about doing what we were doing before they changed the law, which is fudging it so that we're doing what's in the best interest of the client and not being zealous advocates? Because if I see something in their home, isn't that their secret, and aren't I ethically obligated to keep my client's secrets at all peril to myself?
I think you are.
So right now, we're just saying, okay, these are the ways. Calling the investigator and exposing your client's secrets is exactly what this law is telling you you're not supposed to do. So it would seem to me that the only thing to do is if I see something bad and I know my client's in trouble, I have to withdraw. And that makes a huge statement too to the court saying, I can't continue in this representation ethically because I know my client's going to get hurt. And otherwise, I don't know how you comply with the ethical requirements of the statute. It's very clear you have to be a zealous advocate, but also protect someone.
In the back.
I think are we, in that situation, don't you just recommend the guardian ad litem be appointed then? Would that be?
I don't think we're going to say that, right? I don't think I have to say my client's incompetent and needs a guardian ad litem if my client's fighting a conservatorship.
Yeah, and that's one of the questions. It's an open-ended question. I know that a couple months ago, I spoke with some of the Alameda County practitioners from Legal Assistance for Seniors, and they were saying that they struggle with these issues too. And they've always been, in Alameda, they've always been zealous advocates and never fudge the line between court-appointed counsel and guardian ad litem. But even for them, it's just uncomfortable. It's right, like if you've bonded with your client, and you see an obvious danger, it is very uncomfortable to advocate for what their abuser is making them say. So it is kind of an ethical morass, and it's something that you have to figure out what you can live with. And I think you're right that probably some of the things that I do might be walking the line, but it's just how I can do it. I live with it.
I guess for me, and being a zealous advocate, is what does it mean in this context too, with the law being so different? What does advocacy mean versus zealous advocacy? Does it mean that I go and object on their behalf and state their wishes, or does it mean that I file this objection stating, all their reasons to object to the court investigator's report? So I'm curious to see, how this law, what zealous really means in this context. Does it mean doing all those things and filing all those things and doing, pickling? So.
We see you, but Dr. Ginne has a thought.
Just one, I only have one per session,
one.
that's it. But I'm thinking, we confront this all the time too, from the psychology world, which is, I actually, frankly, I started my career as a social worker for visiting nurses, so I was in everybody's home all the time. And I used to say that if a picture's worth 1,000 words, being in somebody's home is worth 1,000,000. Because you really get to see what the conditions are and what the situation is. So I think it's invaluable, and I would never, tell you to not go into houses or not make your observations, because that's so vital and important. But I do kind of think that your observations might be used, maybe not so much in the court setting, but more to inform you about your client and who to bring in to help you. And that's where I think the psychologists come into play, because not only can you rely on your court investigators or in certain circumstances the guardian ad litem, but you can also bring in those of us that do these evaluations on a regular basis, and we will probably make the comment. And then as the attorneys, you can rely on our reports to give you the information that you need.
Yes,
There was a-
so Mike.
I think it's Mike.
I think a lot of this is the result of attorneys talking with themselves advocates. And so the idea of legislation and a lot of lobbying that is done by people who have problems with conservatorship was attorneys weren't being attorneys. It was like beyond being a zealous advocate for their client. Being a zealous advocate is black and white. There are court investigators that can fulfill the role of reporting irregularities, but that's not for the attorney to do. I think that's what the law is saying. And the problem in the past is that attorneys, and I know from personal experience, where I have been engaged as a private counsel, and the court is also appointed attorney, and the court-appointed attorney is acting in the best interest, and you're oftentimes sharing attorney-client privileged information. So I think the idea of this lesson law and the way it should be interpreted is that it's black and white. If you're a self-advocate, you can't share information or communication with your client to the court. If you're a defense attorney, you will do that. In criminal settings, so that's what it is. And I'm concerned that it's still going to be this hybrid thing. I think that's, and if somebody has an issue with capacity, you have to deal with that. And I think if you're being retained collaboratively, I wouldn't represent a client unless the doctor said that person has capacity.
And my advice is, if you think that you have to send a client to a doctor before you represent them, you probably should not be representing them.
No, I don't disagree.
That's what I think.
Mona, let's,
I agree with them, because if someone's over 80 and they want an aggressive litigation position, I think that's great to cover yourself and say, okay, now I feel really confident as a zealous advocate that this client can actually guide the litigation. If they can't pass, if I send them and I say, you're 80, I don't want to get into a $200,000 litigation with you unless you're competent. I want a doctor's note, I think that's really smart, I don't think that's a bad idea at all.
All right, Mona?
I have a question. If you're court appointed as counsel and you feel that your client really does not have capacity to be communicating with you, do you feel it's appropriate for you to advise the court that a GAL should be appointed? Or do you think it's inappropriate as court appointed counsel to have an opinion on whether a GAL should be appointed?
Well, that's a good question, because just by saying that a GAL should be appointed, you are endorsing the idea that they lack capacity.
Right.
So, is there a way to do that? I mean, I think one of the issues is that you are an attorney and counselor at law. So I would really try to talk my client into agreeing to that. Now, if they can't speak, if they're unable to communicate at all, then I do think that you have a duty to say, I was unable to get my client's input, or, you know. And then I think at that point, it is up to the judge to request a GAL. But if you can have any kind of conversation with your client, then you should encourage them to go along with the idea of having a GAL to help them.
And just one quick follow-up question. The mention of being a zealous advocate, does that include, or has the legislative language or intent talked about the requirement of back court appointed counsel to appeal? Like, where do you end as a zealous advocate?
I believe so. I think you're supposed to. It doesn't end. A zealous advocate is a zealous advocate. Like Mike was just saying, that's what zealous advocates do. They push it all the way.
Well, I think that it's unclear. I mean, I think the law is unclear. My reading of it, and like, I know that in Contra Costa County, if you're appointed as court-appointed counsel and you want to appeal, there's not funding for that.
Well,
as a practical matter.
But generally, you could submit, you could file an appeal, but then there would be another court-appointed attorney at the first circuit court of appeal. So that's just how it goes.
Well, I think I was just gonna say, if it's paralleling the criminal defense line, then when the matter is completed, you can terminate your relationship with the client. I mean, it sounds to me like it really, the legislative intent was meant to kind of mirror our advocacy for criminal defense attorneys, which is, you know, unless they're committing a crime or about to commit a crime, you can't say anything. You can't pass judgment, you have to zealously represent them until the matter is completed, and then you withdraw.
Yeah, but I think.
There's no gray there at all.
Mm,
And some of the pushback that I gave.
No, well, okay, but so there's Tarasoff, right? There's a duty to warn. If there's gonna be a future crime committed and you know about it, you can violate attorney-client confidence. And my thought in this is, if I am seeing an obvious objective danger for my client who is being abused in some way, that to me, I analogize that as to being aware of a future crime and having a duty to warn. And so, as black and white as anything is, we're all lawyers, nothing's black and white. Every word can be challenged. You know, what does it mean? So that's why it's good to talk these things through, because I do think that people have different ideas.
Yeah, and there were very few court-appointed attorneys involved in the penning of any of this legislation, just so you know. And I brought up what happens when you have a client in perhaps a limited conservatorship who has no capacity to communicate. How am I supposed to zealously advocate there? And they're like, what does that even mean? I'm like, oh gosh. And they just, I got blown over.
Dan?
In a situation where, you know, you're getting, the client is, the proposed conservator is saying, this is what I want, this is what I want to charge, this is what I want to happen. But you know they're just parodying what they've been fed from the abuser like 10 minutes before. Does the attorney have to have a genuine belief that what the person is saying is true, or is it literally literally the words coming out of their mouth is what you need to be asking for.
I would say literally the words coming out of their mouth. What do you say?
Oh, I'd say, no, you can't file frivolous lawsuits. You have to, that's just, you have an ethical duty to not file frivolous suits. And so if like was brought up, that you can reach a point where you can withdraw. So you have to keep that in mind. That, and I think that might be the remedy for all of this eventually. And if you are court appointed and in that position where it's just not a workable situation, something might have to give. That I cannot pursue this litigation because it is, doing a noisy withdrawal might be the solution because it's just not going to work. I think where a combination of zealous advocacy has been brought up, that it is black and white there. And, how do you get out of that withdrawal?
I want to be sure to give Dr. Ginne lots of time to speak. A couple quick things I just want to point out that are sort of open areas. I think that how long court-appointed counsel serves is a really good question. I would say that assume that you are court-appointed counsel for the duration unless the court tells you otherwise. And that would include, I guess, appeals. But I think if I got to a point where it looks like we need to have an appeal, I don't feel qualified to do that work. I don't do that work. And going back to how the attorney needs to be qualified and have the right qualifications, I would probably ask the court to release me and appoint appellate counsel.
You can initiate the appeal, and that's all you'd have to do.
And then we know that the courts are placing closer scrutiny on attorney's fees and fiduciary fees. So be aware of that. And that was another abuse that caused the public to sort of rise up and be leery of conservatorship. So watch your fees.
Always watch your fees. And I think this is one thing that gets out of control, and the civil world has reached its hands into the world of probate litigation, and conservatorships have fallen victim to that the fees have gone out of control. But some might argue, well, that's zealous advocacy on all fronts, and that's just the price we pay. And I don't know, is that the price we pay?
And to touch on guardian ad litems, which to me are so necessary now that I think I'm more comfortable personally as a guardian ad litem because of my personal bleeding heartness or whatever. But I think that there's still a lot of confusion between our colleagues about what is the role of court-appointed counsel, what is the role of guardian ad litem, how do we work together, and I think it's really important for people to stay in their lane. Yeah.
How do you guys feel it would be appropriate for guardian ad litems to be selected? Because from what I've been seeing, it's been the petitioner who's bringing this conservatorship, and then they're slating a guardian ad litem that they're choosing, and it's like a, hey, wink, wink, I put you in, don't screw me over situation, which is really inappropriate. And so, it seems to me that if we have a mechanism in place where there's a conflicts panel that's appointing court-appointed counsel, shouldn't that same practice carry over with guardian ad litem? Shouldn't the same educational requirements be imposed on jails as well?
Yeah, and I really want to push, I think it's inappropriate in Contra Costa County the way it happens. It's, the judges just pick the attorneys they like, and there's like 5 attorneys that they always pick. And that's weird, and then also having a colleague choose you because they think that you're gonna agree with them is also weird. So I am pushing for the conflicts panel to take over that role, so it is more fair and appropriate, and that there are real discernible standards about who should be GAL. And in in Alameda County, that's how they do it. They have a rotating list of guardians ad litem. You don't get to cherry pick. But it's an issue, and it's a question that we should keep in mind. And then
And I think something like that needs to start with, you could address it, a good place to address it is with the local bar association. Bring it up to the bar association, they can bring it to the presiding judge, that this needs to change. We need a system, and because that's how it started with the court-appointed list. And so these things don't just generate out of thin air. It has to start somewhere, and that's how it starts. So bringing it there because they meet quarterly with the presiding judge and staff, and so that's the way to get it in there, and that way they know, and it can get addressed. Otherwise, I would suggest a dance-off personally. It's just me personally.
And, another hot issue is when you let the family in, how involved do you let the family be? There was a change to the law that allows people actively involved in the litigation, third parties to be present in a meeting, and it doesn't destroy the privilege. But even though that exists, is it ever a good idea to have the family members? I think that's something that you need to ask yourself.
Have them in what, in the meeting?
In a meeting, in any meeting, or bringing them to the meeting. People do it all the time.
They do.
So, something to be aware of. I'm zipping through these slides because I want to give
Yeah,
Melinda.
one of the big clues is when you ask a question and the elder looks over to them for the answer, it's like, oh, you know that. The you know that. He knows that. John knows that. Bob knows that. Let him know. Like, oh gosh, here we go.
Okay,
So-
I think a lot of estate planners, I know a lot of estate planners let family members in because then we see them in conservatorship cases with shitty estate plans that they did the day before they were concerned. So, yes. And now we're gonna hand it over to Melinda and we'll have more questions.
Oh, but really fast, I know you had on one of the slides the role of the original estate planner.
Yeah.
If you're an estate planner, do some due diligence, good gosh. If somebody shows up to your office and decides that they now want to change their estate plan and leave everything to one member of the family because everybody else stinks in their family, don't do it. Knock that off. I'm sick of seeing the litigation that follows afterwards. Please stop doing that.
Not even in my practice.
I'm like, oh my God, it's just driving me crazy because they do it again and again and again. And it's just so annoying. And I know it's a traveling circus. They go from one attorney to the next until somebody does it. So just, I think if everybody stopped doing it, the world would be a better place. So please, for everyone's sake.
And it's really hard to tell who has capacity and who doesn't, and when you should say yes and when you should say no. So that's where Dr. Ginne can shed a little light on what to look for and how to proceed, sort of.
Yeah, I want to say that all these issues are so interesting because there is a lot of overlap. And so I'm coming today to represent, I guess, one of the people that you might call in on a case. I am a geropsychologist. I'm also in the psychology world, what we call a behavioral medicine specialist. So basically, I'm the psychologist that treated all the psychological aspects of major medical illnesses, and I've spent my entire career working in medicine. The thing about capacity is that we're looking at it all the time whenever we talk to our clients. I mean, that's something we're always thinking about. I'm sure you're all thinking about. It impresses me that most of you not only have that foremost in your mind, but that you have become experts in how to assess it, which I think is really, when you work in geriatrics, you have to wear a lot of different hats. And I think that that's really important. Of course, we're always looking at whether or not the person has the ability to make their own decisions. And as a factor of that, I'm talking about exactly what you've been bringing up, which is undue influence. And we do see it all the time. The problem with undue influence is that it can be so subtle. And by the time you might be seeing the client, they've been groomed for years by their persuaders. And so it seems seamless. And when you have a client who says, oh no, I definitely want to give this one child 75% of my estate, and that child is sitting there kind of like licking their chops, and you just know that they've been there on the case, for years and years, already telling the mom that they're the best mom in the whole world, and their siblings are terrible, and all these kinds of things. So we see it all the time, one of the things about your role as the attorney is that you basically are ethically obligated to make sure your client understands what's going on and that you understand them. So in a capacity evaluation, everybody is presumed to have capacity unless you can demonstrate otherwise. And that one of the things about being an older adult is you absolutely are entitled to make very bad decisions, until you've been deemed to lack capacity. And I also used to see this all the time where, people would, as I said, they decide on one child to endow, or, they would decide, I just recently, actually still currently have a client who believes she can leave a locked unit and have her own apartment in Carmel. And so, you see people that make really bad decisions or think that they can, and this is exactly what you're talking about. Where do you kind of draw the line between, endorsing what your client is telling you and knowing that there's probably something different and that is probably not in their best interest. So the focus of evaluations is to determine if they can make decisions or if they need someone else to do that for them. And the thing about capacity, and this is, I think, what we're talking about today, is that it's really no longer an all or nothing situation. There are shades of gray, there are variations. You may want to say, well, yes, they can make decisions about this, but not necessarily about that. Or in my reports, I always write something that says they may not have capacity for certain kinds of decisions, but they should always be engaged in the decision-making process. And I also add, however, if there is a conservator or another agent, trustee or something like that, then the decision gets deferred to them. So ultimately, whoever is watching over them really has the ultimate say. So this is what we look for as psychologists when we're doing capacity evaluations. We comment on things like alertness and attention. Can they process information? Do they have basic and executive functioning? So executive functioning, it's like, in the front of the brain, and it's basically the things about organizing, thinking, processing things through. It's abstraction. It's very sophisticated kind of thinking. And you want to know, what is going on with their thought processes. Do they have delusions or hallucinations? And of course, many of my patients do, because they've got maybe advanced dementias or dementias of a certain type. Can they modulate their affect? And then all these capacity evaluations involve a comment about their activities of daily living. Can they do their banking? Can they go to the market? Do they get lost in familiar places? So we always comment on that. So executive functioning involves things like, can they make good decisions? Have they been making good decisions? Do they learn from negative feedback? This is a really important thing. So if they leave a pot on the stove and it burns, do they then watch their pots after that or not? So does feedback give them, in other words, are they profiting by their mistakes? Can they live without supervision? Now, most of the people I see, they need somebody else there to help them. Because they're just not independent livers. I mean, they may need just assisted living somewhere, or they might actually need a family member to help them. Do they need behavioral management? So are they doing things like, if they're living in a facility, are they able to cooperate with the rules of the facility, or do they act out? Usually a lot of the cases I see, the Adult Protective Services has been involved in sometimes in some way or another. Especially when you see high conflict families, then you see that at some point somebody's called APS on somebody or other, whether it's the perpetrator or the victim. And obviously the question we're always asking is, do they need to be conserved? So here are some of the indicators that are not just on a paper and pencil test. So you get information from collateral sources. Also, as we were talking earlier, if you're in the home, which during COVID, I haven't been in people's houses, but I'm going back into their houses now recently. And so you get to see what is going on in their house. And sometimes children will tell me, oh yeah, my mom ate a really bad, jar of cottage cheese last week, because she can't tell the difference and she doesn't know what to do. And so this is things I'll comment on in my reports. I'll say something like, patient does not know to take out the trash, so she was getting mice in the house. So we also look at the things that have been coming through, like bill paying. Can they get to medical appointments on time? I practiced at Heisler for 20 years. The receptionists all knew my patients because they were all there on the wrong day or the wrong time, or they didn't know what department they were in, and they would always go, oh yeah, Dr. Ginne's down the hall. So can they get to their medical appointments? Can they take their medication? Because as we already know, medications play a major influence in mental status. So if they're taking 3 of their heart medicines in the same day, how is that going to affect their ability to think things through? Or if they're taking 3 of the Seroquel that they've been prescribed because they, their thinking isn't very good and they're calling mommy, mommy, mommy. So if they take too many medicines, what does that do to their mental status? So also things like social supports or isolation, the presence or the lack thereof of supervision by family members or professional caregivers, paranoia, hallucinations. Paranoia is going to make a huge difference in somebody's ability to participate, not only in estate planning, but then a plan you come up with for them. So if somebody's really paranoid, like I have a patient right now who's pretty paranoid, and when I read the medical records, almost every emergency room visit that she had, they'll say, patient very guarded, couldn't get any information. And that's, part of what happens. Again, APS involvement. What kind of insight do they have? Like the person who wants to move to Carmel, really what kind of insight does that person have about their circumstances? I will tell you very little. So, and that's also really important. Because when you're trying to do an estate plan with somebody who doesn't really understand their circumstances very well or have much insight or learn from their mistakes, it's a really different kind of estate plan that you're going to be putting together. So some of the indicators that you might see of when a mental capacity assessment is required are things like, do they have a general understanding of the decisions that need to be made and why? Do they have an understanding of the likely consequences? Those are very important for you to know and to weigh and to measure. Can they understand, remember, and use the information provided to them when making a decision? And can they communicate that decision? And what happens if they repeatedly make unwise decisions? So I had another patient recently who had what I would call very bad judgment and very little insight, and she got COVID. So that happens, especially if you live in, congregate living, or if you have family members that come in and out of the house that may be exposed to it. It's not uncommon, we've seen it a lot. But she didn't believe that she had to wear a mask, and she didn't believe that she couldn't go out in public without a mask, or even, going someplace that she would take her mask off, like the doctor's office or a restaurant or anything like that. She kind of thought, well, I don't understand. I need to go to a restaurant, and I should be able to, surely you're not talking about me.
If that's a marker for incapacity.
I'm not liking any of these markers for incapacity. I'm looking at them like, hold on a second. Repeatedly makes unwise decisions that put you at serious risk.
Like if they run for president again after.
But he was tested, so, he was given a manual on TV, whatever. I know, sorry.
Okay,
Yes,
sorry.
of course, you're just commenting on your own personal checklist, like, yep, I know.
I was in the room.
So, obviously, okay, so they make an unwise decision. Okay, so, psychology function, this is what we do, basically. So we're looking at, I say we take a very, well, I'm gonna talk a little about geropsychologists versus neuropsychologists, but as geropsychologists, we use a very wide palette. So we're always looking at cognitive, behavioral, and psychosocial indices that characterize normal aging, so we know what's not normal. And if you don't know what normal aging is all about, just follow me for a day. I'm the model in normal aging. Even if I'm putting my keys in the freezer, oh, that's normal now. So, everything becomes more normal as you become a member of the club, I'll tell you that. It's really funny too, because I'm teaching a class now on geriatric mental health, and my students said to me just like this week, they said, I said, okay, so I'll see you all next week, and they go, no, 2 weeks. And I said, oh, and they said, yeah, it's Thanksgiving, and I was like, oh yeah, I knew that. I was like, okay. So we incorporate the developmental, the medical, and the psychological history of the patient. I mean, I can't tell you all the times where I will have a spouse in the room with me when I'm doing an assessment, and the patient will say to me, I say, well, who's in your family? And they go, well, there's, we have a son, and then there's we have a dog, and I'll say, oh, well, what's their name and how old are they? And the patient will look at their spouse and go, honey? And then the spouse will say, they were never good at names anyway. So, I mean, like, that tells me a lot. It's like, this isn't recent. This is something that's always been there. We have to account for comorbid and reversible conditions.
So you allow the spouses to remain, or somebody to remain?
Yeah, I know that question came up. You know what? I do. Neuropsychologists don't necessarily do that, but as a geropsychologist, I do. What I do, though, is I do have a technique for dealing with it, which is that I tell them that there's an invisible curtain between them and that the spouse can't help in any kind of way. And so, of course, in the first 30 seconds, the spouse is trying to help. So, I'll say to the patient, what's today's date? And they look at their spouse and they go, well, what is it? And the spouse goes, oh, it's June 30th. And I say, that's a really good example of how you can't help. So I'm always waiting for them to do it. I do it because I want them to be there when I'm doing my exam. I want them to see what I'm doing. I want them to hear how the patient interacts with me. Because for so long, family members have been they've been kind of adapting to somebody else's loss, and they don't see anymore how bad it can be or what it's like when they're talking to somebody who's like an original person for them.
I think that's a really good point. Like, there's a couple reasons to have family members around, certainly during a neuropsych eval, but family members are often in denial, especially children, about their parents, right? Because this is the biggest figure in their life, and now all of a sudden the roles are flipping, and it's a really hard adjustment, and people are not objective. And then the other part is that when I can imagine when you're meeting with a lawyer or you're meeting with a psychologist because of age-related concerns, you feel bad and you feel attacked, and it's probably comforting and making things clearer for you to have your person nearby, right? Like, it's less confusing even if they're not saying anything, to just be able to look for that reassurance. I don't know.
Well, so we have a template for it. because we do couples therapy and we do family therapy. So there's already a template for having other people in the room. And we don't have as present for us the issue of attorney-client privilege that you do. The other thing is, it's almost always gonna be the family that's gonna carry out my instructions and who's gonna also be the keeper of what was said and done.
What if it's the abuser?
Oh, that's the other thing, is you do have to be very careful about that. And usually, so I do monitor for it, and right now I'm working on another case where undue influence is probably front and center, and so then I do interview the patient by themselves. Well, I call them patient, the client. I do interview them by themselves, and I don't allow family to be there. Yeah, so we have to use discretion. But for the majority of my cases, it's usually more concerned spouse than it is abusing spouse. Yeah. So I just want to comment quickly about comorbid and reversible conditions, because it's really important for you, I think, to know that there are definite medical conditions that can cause people to look demented, and they're not. And if only their medications get adjusted, or nutritional deficits get adjusted, or any kind of toxic environmental concerns get addressed, you might have in front of you somebody who's actually capable of participating and competent and not lacking capacity. We also, if possible, interview family members or collaterals. That's important for us. A lot of my exams have collateral versions to them. So I may give a patient like a depression inventory, but then I also give it, I ask their spouse or their family member, whoever, to also comment on the patient's mood. And this is, again, something where I have to be thinking right away. It's like, is this somebody who's possibly trying to harm the patient? And then I obviously don't use them. In the case I just told you, where I'm talking to somebody where it's pretty clear that undue influence is front and center, I won't give them collateral tests. Or I don't even think I'm going to end up interviewing anybody. The other thing is we review medical records. And this is, I would say, maybe almost equal to the testing I do is what I can find in a medical record. And I just did test a patient where a neuropsychologist also tested them about 3 years ago, and they thought that the diagnosis might very probably be frontal temporal dementia. And then I looked at the medical records and I saw that the same symptoms were present in 2019 that are still currently present, and they have not significantly I haven't seen significant change in them. So I'm looking at static kinds of symptoms, and that's really, really important for me to know, because what it basically means is I'm not going to be predicting that the person is getting worse, but I am going to show that there's this very significant element of impairment and how to kind of work around it and how you would work around it. Okay, so geropsychologist, which is what I am, and by the way, I want to say that, when Lara says that she became involved in working with older adults after having been a criminal defense attorney, I would say that in the world of psychology also, you kind of basically know, or if this is your field or not your field. I was exposed to older adults very early on in my practice. I knew right away that I really liked working with them. There's something about working with people who are inherently vulnerable. You don't have to top dog them. It's like there's no percentage in, holding, sway over somebody who's so vulnerable and they need help. All of these people that we see need our help. And so that's why I chose the field of geropsychology. I say I kind of fell into it. But I have been a geropsychologist for about 30 years now, a behavioral medicine specialist for 40. And so what we look at are the, how do they cope with and manage chronic illness? Do they have behavioral issues? Are they dealing with grief and loss? What are the family caregiving strains? We look at end-of-life care. And I say geropsychologists take a 360 view. I'm going to compare that right now to neuropsychologists. Neuropsychologists are really, really mostly interested in the brain and behavior. the interface between brain and behavior. And I was talking to a neuropsychologist the other day, and what she said to me was, she also does work in the legal field, and what she said is that all she's interested in is the facts. She just wants to see what her test data tells her, and then she, makes her interpretation and analyses. And I'm really interested in seeing the whole picture. So I say, my joke about myself is, I would rather know how you get to the market than what your mother was like. So I'm really interested in, very practical kinds of issues. How are you managing to live your life? And that's what my reports will look like. I'm going to comment on all of those kinds of things: your environment, your family dynamic, your previous medical history. Are there reversible conditions that need to be treated now? Who needs to be involved in the patient? So I say I take a 360 view in that way. Here are the exams. I thought it might be interesting for you just to see the typical exams that any one of us will administer. So I always start with an interview of the patient and collaterals, and then I will do the mini mental status exam. Now, I will warn you, something you may already know, which is that it's a really bad exam. So it's you can, there are 30 possible points on a mini mental status exam. You can miss 3 by not being able to answer any of the 3 memory questions. So you can miss 3 points and still pass the exam and not show any indices of impairment. It's really bad, but it's the gold standard. It's the gold standard in medicine, and it may be in law. That, everybody administers the mini mental, so I always include it because
Is that the one with the clock?
Sorry?
Is that the one with the clock?
No, I'm gonna tell you about the clock in a second. No, the mini mental is the one like, who's the president, although they don't actually ask that question. But you get 5 points for knowing where you are and 5 points for being able to give me the date out of 30. So 10 points a third is just if you know where you are and you know the date. And then, as I said, you can miss all of the questions about memory.
Well, I'm just looking at the date.
Okay, look at the date.
I wanted points for the date.
I know. You do have to say, when you say, tell me today's date, you do have to add, and don't look around and don't look at the calendar, just tell me what today's date is. Okay. So the other really common screening exam we give is the MoCA, the Montreal Cognitive Assessment Scale. It's a much more sophisticated mini mental. Am I still good?
Yeah,
Okay. It's a more sophisticated, and the thing about the MoCA is it comes in 50 different languages. So I will tell you this, that even if somebody seems fluent in English, if they're Chinese, Spanish, Tagalog is their primary language, the data is that they miss 60% of whatever's being communicated to them, even if they're fluent in English. So the MoCA does have the clock. I'm going to talk about the clock in a second, but the MoCA is the one that Trump used to refer to when he said they asked me about man, woman, TV, and something. I forget the other 2 things. Yeah.
I just have a question about what you just said. Somebody whose first language was not English.
That's right, not English.
But it can't be that everybody is 60%.
No, that's just that's the normative standard. It's in medicine, by the way. I should say that. It's in medicine that they will, I don't mean completely miss, but they may misunderstand. They may not get directions right. They may not be able to fully and comprehensively answer. So in medicine, we always take that into account.
Okay, so
Yeah,
it depends on how long you've been here.
Yeah. Acculturation is very important, but it's really thinking about what their first language was. If it's other than English, you have to be a little bit careful.
Yeah.
Just to follow up on that, if people are experiencing some beginning phase of dementia, do we know if they lose their newer languages first, or because I know that they would go back to their oldest memories.
Yeah, that's right.
So if we're concerned about dementia and they're speaking English, but we know they also speak Spanish,
Yeah.
that's what we should be looking for?
Yeah, that's right. Yeah, that is really true, that if somebody, even if they were, bilingual, or, if English wasn't their first language, they will very commonly revert to their primary language as they get more demented. Yeah. And I actually, I'm considered bilingual by Kaiser, which is sort of a joke, but No, but I was, and they test you actually, so they don't just say, oh, you seem bilingual. And I have to tell you that I was the psychologist in the Latino medical clinic at Kaiser, and that I had to test so many patients. I worked in Oakland, so we have the Fruitvale, so we have a lot of people that are monolingual Spanish. And to test somebody in Spanish who's demented, it's like I couldn't tell where the dementing began and stopped because it was like, I couldn't quite tell, it's, in a different language. Was that a colloquialism? That people would talk to you or say weird things to you? Or is that like because you're demented that you're saying that? So it's really important. And at Kaiser, we actually had very, very good access to translators. So, okay, one of the other screening exams is the SLUMS. It's the St. Louis University Mental Status Exam. It's so bad. I actually had it up here for you to see, but I don't have it on my desktop anymore. But it's just really like, what is this? What kind of a graphic design is this? It's like, oh, that's a circle. Okay, you passed. So we also look at financial capacity measures, and there was a little seniory thing that I did there, which is I didn't conclude my comment in the parentheses, but that's okay. I think it's because I was going to go back and look, because really the most common financial capacity measure, I think, is the Lichtenberg. Okay, I also use the repeatable battery for the assessment of neuropsychological status. This is again a pretty comprehensive exam, and it tests memory in 3 different domains: memory of lists, a story, and a graphic design. And I also use the CEFI, the Comprehensive Executive Function Inventory. This is a self-report exam that's administered electronically. So I send the exam to the patient, they fill it out, and they return it to be scored. And this is also one that has testing for collaterals. And then for me, they will give a comparison report of what the patient said versus what the collateral said. And so that's really helpful. The clock is what I consider to be one of the best exams out there because it's so easy. It's so quick and dirty. You guys can, I don't know if any of you ever use these exams yourself, but basically you say to the person, draw a large clock face with all of the numbers and set the hands for, one of the examples is 20 after 4. And if you think of what does the clock look like at 20 after 4, both hands are pointed on the 4. I use the version I learned, which was 10 after 11. And people have so much trouble getting the 10 after the 11. 10 after 11 should be, 11 and a 2, but really they try to get the 10 to, go around the 11. You'll see all kinds of different variations of it. It's, as I said, very quick and very dirty exam that tells you a wealth of information.
We're gonna have to get a replacement for my generation.
Yes.
I barely learned how to tell time, and anybody younger than me, just because I'm not. I just had a mental block about learning to tell time, but I don't think my kids know how to read a clock. It's just crazy.
I know, it's really sad that it's actually gonna get replaced because it's such a good exam. So we also use, the dementia rating scale, a Wechsler intelligence scale, because there's a very good scale on there for premorbid intellect. And also use the Wechsler memory scale sometimes. In terms of mood, the PHQ-9 is a depression inventory. I also use the depression scale. And then the Lawton, Brody, and the CATs are 2 measures of activities of daily living. So I just wanted to show you those really, because I wanted you to get such a good idea of what you should be looking for when you retain somebody like me to do your evaluations for you. I've seen so many reports because I read them all when I'm looking at a client and when I'm doing my assessment. I read what previous people have done, and I've seen so many where maybe they do the mini mental and that's it. But really, they should be much more complicated, much more involved. They should have a lot more measures, and you should be able to get a lot more data. So Rachel, did you want to say something?
Yeah, I have a question. What about education level with these tests? How much does that that are better for people with, high school education or versus college?
Now, these tests, one of the things about them is they're all standardized and they're normed. So, I mean, a certain test, like I think the MOCA might give one point. If you have a lower education, you get an extra point or something, so it tries to balance it out. But for the most part, all of these tests have been normed on, thousands and thousands of patients that, you'll see all the different variations in abilities and educational background. Yeah, and I test, we're also kind of trained, I'm trained in this way, which is, I kind of practice in what's called the Boston process approach, which is I'm not always just looking at the numbers, I'm looking at the process in which the person takes the exam. And it's the same thing about analyzing the exams, which is, I'm not always interested in how they scored on the exam as I am seeing the trend and the tendency and commenting on that. So if I see one exam where, they're showing memory loss, I want to see that on the other ones as well in order for me to comment on saying, yeah, there's clear memory loss.
And are you watching them while they're taking these exams and the time it takes them to, like the clock, for example, how long does it take them to do the clock?
Yeah.
If it takes them 5 minutes to do the clock as opposed to
30 seconds.
30 seconds to throw something down.
Yeah, exactly. And I just had a tested a patient a couple of months ago on them using the MOCA, where one of the tasks is to replicate a two-dimensional drawing. And there are several versions of the MOCA. As I said, there's 50 language ones, but there's also 4 or 5 different ones that in English, so you don't come up against like what we call retest sort of issues. So it's not like they go, oh yeah, I just did this one last week, that's a blah, blah, blah. So you want to do novel kinds of tests. And one of the tasks is to draw a chair on one of the exams. And I had a patient who literally took about 15 minutes, and it's about a 30-second task. And so my report was all about, obsessive compulsive, didn't understand the task, things like that. So yeah, comment on all those things. Okay, so I'm going to try to get through my slides in the next couple of minutes, but you can still ask questions. So in terms of conservatorship, our job basically is to presume it's not needed, and then identify the reasons for the concerns. And again, is it reversible? I want to know what kind of community supports there are for the client in case I do find some kind of cognitive impairment. And of course, the whole topic we're talking about today really is about appointing advisors and guardians, essentially. Also, I think you probably all know about supported decision-making, which is where, people who need assistance basically get the exact kind of assistance that they need, whether it's financial or medical or to establish their trusts. There's something also in the medical and psychological world that's called person-centered care. This is a pretty big movement, and I think it should be a really big movement in terms of the work that we do, trying to establish conservatorships, which is person-centered care. And this is really saying that it's a way of providing care to people by looking at their uniqueness and their preferences as opposed to their diseases. So we do diagnose. That's part of what we do because that informs everybody. But it's also really important for me as an evaluated to take in the personal, the human aspects of the client and try to incorporate them into my recommendations or my diagnoses. It's also really important for you as providers to these people to be able to adapt to their cognitive decline. So things like beginning the interview with simple questions. When I'm testing, my protocol always starts with the easiest test first. And then I build up. If they're unable to do my easy tests, which is like the mini mental, I have to scale back. I do not proceed. My job is to not frustrate or, cause distress for my client. So a lot of the times I do not get all the way to the end of my battery, even though I try to. And in most of the cases I can. We all need to conduct business at a slower pace. That's the way it is with older adults. They have to have time to process things. You're going to come into a lot of sensory impairment, hearing. I have really bad hearing. And so if people don't speak up and look directly at me, I have to I have to say, hey, I can't hear you if you're walking away from me. I need to look at you when you're speaking, and also people need to speak clearly and and a lot of the time slowly in order for me to hear them or get what they're saying. I have to allow extra time for responses. It's really common for people to have word finding problems, which is incorporated into my discussion of their mental status, their cognitive status. But also, if I don't give them enough time to describe to me what it is they're trying to tell me, they won't be able to communicate it. It's really important to break information into smaller, manageable segments. I have had so many people say to me, can't you put that in a farmer talk? And it's the same thing probably with you. Your conversation, your thinking, your framework is so complicated probably for John Q. Public that I'm sure you have your own ways of breaking things down so people understand the concepts that you're trying to communicate. You may want to only discuss one issue at a time. You're going to repeat and paraphrase and summarize what the person has told you so that you make sure that you're understanding it correctly and to their satisfaction. I used to always say things to them, ask them to repeat it, I would put it in writing, and then I would confirm it. Because if information is not understood or incompletely understood, you need to keep checking to make sure that they're comprehending what's being said to them. Providing summary notes, scheduling appointments for the time of day when the patient is at peak performance. I do that all the time. So except I won't go like really early morning, that's not my peak performance. So if they're, so I will say all the time, what's the best time for you? And some people will give me really narrow windows, between 1 and 2. It's like, okay, well, let's make this for between 1 and 2. You need to provide time for rest and bathroom breaks, schedule multiple shorter appointments rather than one lengthy one. And they say, basically whenever possible to do it in the client's residence, which I'm sure each of you has your preference. This is important, is to just remember that everyone is fighting a great battle. Everybody we interface with is challenged and is struggling, and the best thing we can do is take time to try to help them. And this is my information. I'm willing to, give Lara my slides or to give the organization my slides if they would be helpful to you. And so I think we have time for some questions if people want to
We have
ask.
time for more questions. Oh, we got some in the front. Let's go.
Emily?
Yeah.
About a year ago, I started noticing, I don't know if you were still at Heisler anymore, but there were certain doctors, mostly at Heisler, that would no longer give determinations. They were very scared to write anything down. Have you seen that in your practice, or now if you're, in private practice, that people have come to you more because the networks aren't willing to do that anymore?
When you say determination, do you mean a diagnosis?
A diagnosis, long notes, kind of anything.
Anything from Kaiser. That's just Kaiser.
Well, like Amber was saying, if you want to have your client, before you represent them, get a doctor's note saying they're okay, there is reluctance from GPs at least to put anything like that.
They wouldn't do it without a court order.
I have to say I don't know the answer to that. I actually retired from Kaiser about 8 years ago. So I don't know what their current practice is. I can tell you that at Oakland, where I was, they didn't really have a geriatric medical clinic. And I would say more likely than not, physicians just didn't know. They didn't know if somebody had diminished capacity or, what I've seen so many times is diagnoses of something like dementia being put in somebody's chart when maybe they're not demented. And so I don't know. I think it can go both ways. I'm trying right now to get some medical records from John Muir and I'm having a lot of trouble, but yeah.
Has your practice picked up more in the last few years?
Has my practice picked up?
Yeah, I'm just looking at, when I tried to approach John Muir and Kaiser, they said, no, go to a private, we're not going to do that.
Oh, you know what, that might not just be for a note, but that might be for an evaluation. Yeah, they're not really doing capacity evaluations in those settings. And you probably don't want them anyway because they're probably not very good. They're probably cursory.
There was a question.
Yeah, I have a question. In terms of the mini mental, I know it's not your favorite, but that is what Medicare will have a primary care physician do. Do you find that it's a good idea to encourage clients to have that every year so there's a baseline should something happen?
Yeah, I would,
Should they
I,
lose cognitive ability?
yeah, I would say that that's good practice, yeah.
Awesome, so let's wrap it up here. Thank you all for coming, and,
Do we want to hang around for a couple more minutes?
Yeah,
yeah.
sign autographs and stuff, and,
Please fill out the review form, and sorry we had to go so fast through some of those.
I know,
I enjoyed what people had to say, and I'm
Yep.
glad that,
again,
thank you for.
evaluation form is out there, please drop it off the registration desk, scan it, email it to Ann Wolf. Thank you everyone for coming out, thank you for
Thanks,
coming out.
guys.